mentioned, I'm Phil Zacchio of Bond's Higher Education Practice, and together with my colleague Gail Norris, we would like to welcome you to today's webinar on top 9 takeaways from the Department of Education's new Title IX regulations, which were rolled out on May 6th. A couple of brief housekeeping notes. This is a 45-minute briefing, and it is not Gail's and my intention to do a comprehensive review of the new regulatory requirements. Rather, this is designed as an exercise in quick reactions. So we are going to attempt in the next 45 minutes to walk you through things that struck us as particularly noteworthy when the final rule was published, particularly by way of comparison to the proposed rule that was published in November of 2018, but also in their own right. We will be doing sessions that do a much deeper dive into particular aspects of these regulations. We'll give you those dates again at the end of the session, but these will be at noon on May 18th, 20th, and 27th, and they will be divided by subject matter. So we'll do deeper dives into particular areas of the regulations at that time. Gail and I are going to use a little creative license with the title today. Our title is Top 9 Takeaways. We've actually got more than 9 that we're going to walk through with you here. So for our working purposes, we're going to call this Top Takeaways in 9 Key Areas of the Regulations. As was mentioned at the outset, there is a Q&A field on your Zoom. And if you have questions, we will, if time permits, try to take some of those at the end of the session. So feel free to enter those as we go along. In the event we don't have time, obviously, Gail and I are both more than happy to connect with folks offline and discuss particular questions or observations they might have. And with that, I will turn this over to Gail to walk us through our first area of noteworthiness, and that is the effective date of the new requirements.
Thanks, Phil. Good afternoon, everyone. So the first bullet point is something that you're probably all very aware of, which is the effective date of these new regulations is August 14th. And despite the fact that the Department of Education wasn't that sympathetic to the work that was needed for higher ed institutions to comply by the effective date, we are certainly very aware of the work that's going to be required to get everything in shape by that date. In fact, our webinars are sort of structured to be able to help you do that, because we think you're going to have to prioritize. You're going to have to pick the things that need to happen by August 14th that you have to do as you're getting ready to welcome students back for a semester, and that you're not going to be able to tackle everything all at once. So our scope of how we're proceeding with the webinars is maybe to help you break it into chunks and prioritize what you're going to need to do to comply. So certainly the first things you're going to need to do is change your policy. It's hard to imagine that anyone's policy is not going to require some amount of changing, at least with respect to the hearing requirements and advisor and decision maker and cross-examination. But policies need to be reviewed, and to the extent they're going to be inconsistent with the new regulations, they need to conform. Along with that, then, will be changes in your training materials. I know many of you train people as the new semester starts, so that's coming up quickly, and to the extent there are policy changes, that will need to be reflected in your training materials. And I think most importantly is a change in the communication materials that you give, particularly to complainants if they file a complaint, so that they know what the new regulations require. Some of this change is going to be disruptively different for people, and it's going to be important that people are well aware what they're getting into if they file a complaint. That's sort of the priority of your to-do actions right now. Also, there needs to be some effort to resolve any inconsistencies with state laws. I know that there are a lot of registrants for this webinar who are from New York, so I'll specifically mention Enough is Enough in New York. While there may not be any areas that are irreconcilable with Enough is Enough, there are clearly tensions between the requirements in the new regulations and what's required in the New York law, and may indeed be in other state laws as well that you'll need to be careful about. And all of this will translate into, some real challenge in putting together your policy, your training materials, and your communications in a way that's clear and not confusing, given that these regulations are not perfectly simple to describe to begin with. Next slide, Kat. Well, the first big area is the school's duty to respond and the necessity of a formal complaint. The first requirement that's in the regulations, the complainant must be participating or attempting to participate in the institutions and programs or activities at the time the complaint's filed in order for it to be a complaint under the Title IX regulations. And this is one area where, at least with respect to New York law, and enough is enough, doesn't go far enough. The New York law is broader in that respect, so you're gonna have to find a way to allow a process to go forward under enough is enough that may not be required under Title IX. There's been a lot of discussion in some of the postings about the school's duty only when there's actual knowledge by someone who has the authority to institute corrective measures. Again, this is for the purpose of Title IX regulations. The comments to the Title IX regulations make it clear that you do not have to limit your actual knowledge or who's a responsible reporter to the Title IX regulations, but this is all that the regulations require. So there'll be an opportunity at a minimum to rethink what schools are doing in that regard. There is a requirement that there be a formal complaint that must be a document that's filed by the complainant. That is a little bit more detailed a requirement than it's been in the past, but it's clear there needs to be a written document and there needs to be some process where the complainant is specifically saying, I'm filing this to start the grievance process under the policy. There's still an opportunity for the Title IX coordinators to file their own complaints. Of positive note, under the proposed rules, there was some mandatory filing requirement by Title IX coordinators if there were multiple complaints against a particular individual. That mandatory requirement's been withdrawn in these rules, but and there is still an opportunity. It's a pretty loose standard for when a Title IX coordinator can file a complaint when there's no complainant. The schools must respond to a complainant promptly in a manner that's not deliberately indifferent. It's the new standard. There's no time periods that are in the new regulations. There was 60 days in the notice of proposed rulemaking. That's been withdrawn. The deliberate indifference standard under the comments is mostly some real pressure on the Title IX coordinator to make sure that there's some mandatory actions outlined in the regs that the Title IX coordinator or coordinators take right away, including contacting the complainant to discuss supportive measures that are available and making sure the complainant understands and you talk through what the complaint process involves. Phil, I'll turn it back over to you for the next slide.
Thanks, Gail. So let's talk about the scope of these regulations. What do these regulations and their 2,000 plus pages of commentary actually cover? What do they require us to do? As you'll all recall, the proposed rule published in 2018 was far narrower in scope than the universe of behavior and conduct that many institutions have historically chosen to address under the same policies and processes that are used to handle Title IX matters. Just by way of example, the proposed regulations set a higher bar for what would constitute sexual harassment with their severe and pervasive offensive conduct standard. There were and are limitations, jurisdictional limitations, for example, the exclusion of conduct occurring outside the United States, the requirement that conduct occur within a setting or context that is connected to educational programs or activities, either by virtue of location or by virtue of the institution's control over the circumstances under which an incident occurs. There in the proposed rule, and this is the change we'll talk about, The VAWA offenses other than sexual assault were excluded. So for example, cases of domestic violence, dating violence, and stalking, unless they also constituted sexual harassment in the proposed rule, would not have been within this universe. And then there are a whole host of other behaviors that many institutions address under their policies and processes, often under a category with a name such as sexual exploitation, things like voyeurism, distribution of consensual videos or photos beyond the bounds of consent, those sorts of things. Under the proposed rule, all of these were excluded from the scope of what the department viewed to be Title IX, which may or may not have been a concern in its own right, but the concern was heightened by a provision in the proposed rules that we've referred to as the must dismiss provision. And it's exactly what it sounded like. It said that if an institution receives an allegation that, even if it were proven, would not fall within what the department has sketched out as the boundaries of Title IX, the institution must dismiss it from its Title IX process, although it remained free to handle it under some other institutional policy or process. That caused all sorts of questions in our minds collectively, I think, in terms of what would that other process look like. So for example, if you had a case of sub-regulatory definition, harassing type behavior, and the department said, thou shalt dismiss it from a proceeding under your Title IX policy, what do we use? Is it a generic code of conduct process? Do we simply say we don't see a basis for distinguishing the processes? So would we have been required to essentially copy our newfangled Title IX policy, establish another policy with exactly the same process staked out and call it something else? This was really an area that was uncharted as far as the department was concerned. And as we'll talk about, it raised some philosophical questions that would need to be resolved. But beyond that, there was a question as to what you could or couldn't do, even if you wanted to. Under the final rule, two important changes. One is an express inclusion of all VAWA offenses. So again, now, and this is consistent with virtually all institutional Title IX processes, if you have an allegation not just of a sexual assault, but perhaps of domestic violence, dating violence, or stalking, all of that now comes in under the Title IX process, and the process needs to comply with these regulations. The other thing the department did was to clarify the meaning of the must dismiss provision. And it still appears in the final rule. It still says that if an institution receives an allegation that, if prudent, wouldn't meet the definition of harassment within the scope of the new regulations, it must dismiss that. But the department has now made clear, with some awkward terminology, but the intent is very clear, that you're simply dismissing it from being a, quote, Title IX complaint, unquote, for purposes of your obligations and for purposes of the mandatory aspects of the process. The institution can still choose to adjudicate that, and if it wishes, can choose to adjudicate it under this policy. So to be clear, once you revise your Title IX processes to meet the requirements of the regulations for purposes of adjudicating things that fall within the regulatory scope, if you decide the appropriate course of action is to keep all of these other types of matters, off-campus conduct, international conduct, under the same process, you can continue to use this process to adjudicate it. It is not considered a, quote, Title IX case, unquote, within the meaning of the regulations. How that gets communicated to parties is a whole other thing entirely, and something I think we're going to need to collectively wrestle with. But you have that discretion. And when I say discretion, I mean that this is an early decision point for institutions in implementation. In many ways, it's almost a gating issue for other things you may do in revising your policies and processes. And that is deciding precisely what universe of conduct are you going to run through this new process that meets the Title IX requirements involving live hearings, active cross-examination, and so forth. You may have some institutions that say, you know what, it is just simpler. Before we did all of this under our Title IX process, we're going to continue to do all of this under our process that is also used for Title IX. it's just going to look different than it was before in many respects. You may have other institutions that say, for one or more reasons, we are not crazy about including within this process anything that we are not legally obligated to. And in that case, the institution, either based on a philosophical reason, what this regulation involves, maybe for a resource reason, we'll talk a little bit here about the possibility of outsourcing certain functions under this new process. It may decide that the expenses of outsourcing are significant, and if we can narrow the universe of cases for which outsourcing will be necessary, the institution may be better off. You may have institutions that peel off some of this other conduct and choose to adjudicate it under a process that has some of these aspects, but not all of them. And there will be trade-offs and there will be considerations. For example, the off-campus conduct. I think many institutions might find it hard to explain to students, for example, why an allegation of sexual assault occurring in an on-campus residence hall room gets adjudicated under this process, but an allegation of a similar sexual assault occurring maybe 100 feet away in an off-campus apartment gets put under a different process. And that may be too much of a leap for institutions. You may feel that even if you have other concerns about this, you're going to bring that off-campus conduct in and use this process for it, but that's a choice to make. The other end of the spectrum, many institutions, their current processes used to adjudicate Title IX matters are not simply used for gender-based behavior. They are also broader policies that address other forms of discrimination and harassment based on other characteristics: race-based harassment, religious-based harassment, national origin-based harassment, and so forth. Again, there, a judgment call to be made. Do you want to use this sort of process to adjudicate those cases, or do you want to peel them off into something that looks more like what you have on the books right now? No right or wrong answer there. Again, looking at that, how do we feel about subjecting those cases to this kind of a process on the one hand? On the other hand, if the process is different, how do we feel about saying, for example, somebody accused of racial harassment is going to have a different sets of rights and limitations than somebody accused of sexual harassment? Again, discretion here, but my point to leave you with in this area is, this is, again, an early decision point for you. You really, before you start diving in and revising your policies and procedures, you've got to decide the universe of conduct to which those policies and procedures will apply. Next slide, please, Kath. Next area to talk about in the proposed regulations is the discussion of supportive measures and interim remedies. And here, the regulations essentially reemphasized what was said in the proposed rule. Supportive measures and interim remedies need to be non-punitive, non-disciplinary. They need to be designed to protect safety and ensure access to educational programs and activities, but are not to be overly burdensome to the other party. Two important takeaways here, things again that jumped off the page at us in reading the final rule. One, the proposed rule included a non-exclusive list of supportive measures that an institution could implement and would be expected to consider. Among those potential supportive measures was a reference to mutual restrictions on contact between the parties. That raised a question in many of our minds as to whether the department was intending to outlaw the issuance of one-directional no-contact orders. Again, most commonly no-contact orders that direct a potential respondent from refraining from contact with a potential complainant. In the final rule, and in particular in the preamble, which discusses the department's views on the final rule, the department has made it clear that one-directional no-contact orders are not outlawed. They are still permissible, but the department is also making clear that the bar to issuing a one-way, one-directional no-contact order is exceedingly high. An example that they give of a circumstance where a one-directional no contact order would be permitted is a circumstance where a complainant has received a judicial order of protection or restraining order against the respondent. In that circumstance, the regulations take the department takes the position in explaining the regulations that a one-directional order may be warranted. Beyond that, it gets murky. The department makes clear that institutions are expected to restrict actual communications between parties, and the department actually seems to be evidencing a mindset that in most cases, restricting actual communication should be adequate to prevent ongoing harassment. But beyond that, for example, preventing close physical proximity. The department says quite clearly that that is not per se a goal that is necessary in every case, but that institutions are going to be expected to evaluate whether restrictions preventing physical proximity are overly burdensome. And just to give you a flavor on their thinking in this regard, at one point in the preamble to the regs, they state that it may be unreasonably burdensome to prevent respondents from attending extracurricular activities. So again, possibly permissible, but a high bar. The other thing worth noting here, many of us, I think, are faced quite often with a situation where a no contact order request by a reporting party is based on the reporting party's concern about seeing the respondent on campus. And the department has taken a harder line on this. The bar here is even higher. And the department's explanation here is that if a complainant wishes to avoid all physical sightings of a respondent on campus and not just communication from a respondent, the complainant may request a supportive measure in the form of a housing reassignment, and the department takes the position that this is not overly burdensome to the complainant because in the department's view, a restriction on actual communication should have been adequate to prevent ongoing harassment. You can find this illuminating discussion at pages 577 to 579 of the preamble to the proposed rule, and I commend it to all of your reading just because it is going to represent, I think, for many of us, a difference in the way that we are used to thinking about the possibility of one-directional no contact orders. For those of you in New York State, as Gail mentioned, I know we have a significant portion today with us who are in New York. This does create some real tension with Article 129B, the Enough is Enough legislation, which obligates an institution to issue an asymmetrical no contact order simply if a reporting party requests it. And one of the things that no contact order must contain is a provision that says if the parties see one another in a public space, it is the respondent's burden to leave the area as soon as possible. How that can coexist with these requirements under the new rule, and in particular the department's philosophy on avoiding sightings on campus, is a very difficult question, and one that I think we're going to wrestle with to think about how the federal rules and that New York requirement interplay with one another. Second takeaway on supportive and interim measures is the department's position on interim suspensions. The final rule provides that in order to interim suspend a student, there must be an immediate threat arising out of the allegation of harassment. That is not a sea change. I think it's not a sea change from the proposed rule. It is also not a sea change from what most institutions use to evaluate the degree of urgency that warrants removing somebody from campus in the form of an interim suspension. The big difference here is the department's definition of what that threat is. And in the final rule, the department has changed a description of this from the proposed rule. And the final rule says that in order to interim suspend somebody, there needs to be an immediate threat to the physical safety of one or more persons, the physical safety. And so when you read that on its face, the obvious question is, what about the circumstance where there's a belief that somebody's continued presence on campus doesn't pose a physical threat, but perhaps poses a threat to the mental or emotional well-being of a party? The department's answer to that question can be found at page 729 of the preamble, where the department asserts that emotional or mental well-being can be addressed through supportive measures offered to a reporting party or another party on campus, and that therefore the requirement is what it sounds like, that there be a threat to physical safety. Can I get the next slide, please, Kath? Moving along through the process, the investigation, the message here in terms of the final rule is really the absence of change from the proposed rule. The structure here is largely what the department rolled out almost 2 years ago. The investigator's role is to investigate and not to decide a case. We all know now single investigator decision maker models are no longer allowed. Interestingly, the department says that an institution could, if it wanted to, allow an investigator in the investigative report to make recommendations as to conclusions or findings. I think an institution is going to want to think long and hard about whether it chooses to allow that in an investigative report, just given the general separation of powers that's being legislated here throughout our process. The rule, as the proposed rule did, requires the institution to provide the parties and their advisors with an opportunity to review any evidence that's directly related to the allegations and that is gathered during the investigation, even including information that the institution does not intend to rely on in reaching a conclusion as to responsibility. This places a premium among other things, and I think Gail mentioned this earlier on, in making sure that both parties understand that if they submit information that is related to the allegation to the investigator, the other party is going to have an opportunity to see that information. And so that expectation adjustment at the outset is going to be important. As the proposed rules did, the final rules require the institution to provide this evidence, access to it, to the parties and advisors, and give them a 10-day period, which can be calendar days or business days, to review that evidence and then make a statement and respond to it prior to the investigator completing the report. Then following on that, once the report is issued, the parties are to be given at least 10 days before the hearing to review the report and consider it. The change here from the proposed rule to the final rule, the main one anyway, surrounds the means by which an institution provides this access. Under the proposed rule, the department was legislating a process where an institution would use an electronic file sharing platform to make this information available, the evidence in the first stage, and then the report in the second stage to the parties. But this platform would not allow printing, downloading, or forwarding. Many institutions use this now in lieu of a requirement that parties review on campus, or in lieu of a process which actually sends copies to the parties. Under the final rules, the department says that the institution must send the information in electronic or hard copy format to the parties and their advisors. That raised a question in our minds. Does this mean that the electronic file sharing platform is no longer available? And the answer is no. In the preamble, the department makes clear that an institution can actually send electronically, email, or send hard copy this documentation to a party and their advisor, but it can, if it so chooses, for confidentiality concerns or otherwise, instead use an electronic file sharing platform along the lines of what I described earlier. And in either of these cases, the institution is still free to establish terms of access which require parties and the advisors to maintain the confidentiality of the information, to review it only themselves without others present, and so forth. There is still that latitude. Next slide, please. Another area where the more things change, the more they remain the same, is the hearing process. I think this was the single biggest question that many of us had in awaiting the final rule. Would the department maintain the requirement for a live hearing with cross-examination? And the answer, not surprisingly to most, was a resounding yes. The final rules do retain the requirement for a live hearing with an opportunity for cross-examination of the parties and all witnesses. The final rules continue to require that that cross-examination be conducted by advisors and not by the parties themselves. And the final rules continue to require that if a party does not have an advisor to conduct cross-examination of the other party and witnesses and wishes to have that cross-examination occur, the institution is required to assign an advisor of its choice to that individual to conduct that cross-examination. As the hearing goes forward, again, consistent with the proposed rule, the decision maker, and in our mind, this can be either a panel and a chair of a panel who does this, or somebody, a hearing officer who makes these decisions, but the decision maker is required in real time to rule on the permissibility of cross-examination questions and to rule on them before the other party or witness answers the question. And the skill set here is basically determining whether the question will be allowed and whether the witness or party will be required to answer it. And as you'll recall from the proposed rule, and this carries over largely to the final rule, there are limited bases on which questions will be disallowed. The main test is relevancy, and then there are specific exclusions for the prior sexual history of complainants, with some exceptions to that exclusion, as well as information about privileged communications, attorney-client privileged communications, healthcare privileged communications, religious counseling privileged communications, and so forth. But the skill set that an institution is going to need there is somebody who is able to make those decisions in real time. So again, an early stage question here: are we going to train people up on campus to play that role, or is this something that is going to be outsourced? And there will be folks out there that are willing to serve this role for institutions. The question is finding them and ensuring that they have the appropriate training. The other question, obviously, is cost associated with something like that. But do you have people on your campus who either have that skill set or are capable of learning it, and who are willing to play that role, presiding over a hearing in which advisors, often attorneys, are having at witnesses in opposite directions and keeping that under control? Similarly, with respect to the obligation to assign advisors, do you have people on campus that are comfortable and capable of conducting cross-examination, are willing to do that? For example, a faculty member, are they willing to aggressively cross-examine a student in a case knowing that that student may wind up in their classroom down the road somewhere? Philosophical questions and resource allocation questions, but ones that should be considered early. And then finally, on the hearing, next slide, please. The rules retain the provision that says that if somebody refuses to submit to cross-examination, the decision maker is precluded from considering that individual's statements in determining responsibility. It's a question under the proposed rule. Does that just mean that that individual can't testify at the hearing, or that their testimony at the hearing would be, for lack of a better description, stricken from the record? Or is it broader? And here the department makes clear it is much broader. It is virtually any statement by that individual. So for example, information in the record about text messages where the party describes what happens, or outcry statements, statements to the police or a SANE examiner, statements on a video that is captured. All of those, if that party does not, or witness does not submit to cross-examination, cannot be considered. Now, of course, that information will have been in the investigative report. What does that mean? Do we need to stop the process, convene a new decision-making panel, and start over? The department makes clear that no, that is not the case, but rather it's a jury instruction type of situation. The decision maker needs to make clear that they are not considering that in reaching their conclusion. Finally, the standard of evidence, the standard of proof. This is fairly simple. You'll recall under the prior rule, there was some consternation with a requirement that if an institution wants to use the preponderance of the evidence standard, it can do that only if that is consistent with its standard of proof under number 1, other student processes potentially resulting in the highest possible sanction that's available under the Title IX process, but also under faculty and staff processes as well. The department has gotten rid of the first of those, so we don't have a concern now if, for example, you've got an academic dishonesty policy that requires proof by clear and convincing evidence, but you still have an issue if you've got, for example, faculty disciplinary processes, or collective bargaining agreements that impose a different standard than that which you want to impose on your Title IX process. Again, early decision point for an institution, because those things typically cannot be changed overnight. I'm not sure whether on most campuses they can even be changed in the 3 months we have left. But if you're going to need to look at reopening a collective bargaining agreement or interacting with your faculty under principles of shared governance and changing the standard under a faculty disciplinary policy, that is something you're probably going to need to get out of the gate on sooner rather than later. Next slide. Finally, appeals, the last stage of the process. In the proposed rule, appeals were optional, but if you offered them, you needed to offer them equally to both parties. This is a fairly significant change to the proposed rule, although not processes for most institutions. Now there is a requirement to offer an appeal for both parties. The big significance here is that they are legislating grounds for an appeal. You must offer an appeal based on procedural irregularity and new evidence, very common under institutional policies, but also on alleged bias occurring during the decision-making process. This is a significant difference and one that I think is going to lead to some incredibly interesting and possibly challenging dialogue when an appeal comes in on this basis. The question here is, are these the only grounds for appeal? The answer is no. The department has made clear institutions may add other grounds for appeal, such as severity of sanction. And with that, I will turn it over to Gail for our remaining subjects.
Okay, the final regs kept in the opportunity that were in the proposed ones for informal resolution. And this may present a great opportunity for many institutions to develop another process that is more attractive to both the complainant and the respondent. Let's go through the requirements and then talk about that, though, because I don't want to spend a lot of time on this right now, because it may be that there isn't the bandwidth to consider this right now. First, that the informal resolution can't even be considered as an approach until a formal complaint has been filed, and then both parties have to agree. That makes sense and is the same as the proposed rule. The final rule makes it clear that this is not an option that's available for any employee on student harassment allegations. Can't use it for that. But again, it is a whole new territory that can be explored that may have some ability for the institution to take back some more control over the student conduct process, instead of what is sort of morphed into two students have to prove conduct and the school is more the impartial arbiter. This may be able to reorient that somewhat back to what is really a school-driven conduct examination. But the skill and training that's going to be required for this kind of informal resolution, since it's not been allowed under Dear Colleague letters in the past, is going to be substantial. There is also the right of either participant to withdraw prior to agreeing to a resolution under this process and return back to the more fully litigated, so to say, hearing process. And I think that's what raises the biggest issue in the informal resolution. I think parties are going to have to be very clear and agree, either pursuant to standard rules or maybe rules they can agree on, or have an option of rules they can agree on up front about what part of the informal resolution process will be able to be used if it resorts back to a more rigorous hearing process that Phil just discussed. There are some very interesting options here, but my guess is that most schools, given the effective date of these regulations, are not going to have the bandwidth to institute this kind of a process. At the same time, they're trying to get their hands around the rest of the regulations we've been talking about. And this, unlike the hearing rules, is optional. The school doesn't have to offer it. So my guess is that for marshaling resources, it's going to be better to shelve this for right now. And I think Bond intends to do a deeper dive on this informal resolution process at a later time when people have the bandwidth to be able to consider it. Next slide. The last requirement is training. Training always has been a requirement. It's not too much changed although it's a little bit more specific that it's required of all Title IX personnel, including Title IX staff, the investigators, the decision makers in both hearings and appeals, and the advisors. If an informal resolutions process is allowed, there's got to be training of the people, the facilitators involved in that process as well. There are some mandatory training requirements in the regs, and it includes training on how to serve impartially, conflicts of interest, and bias, which was not a delineated area in the past. The frequency of training is not specified. It doesn't have to be annual, so the schools can think about how they want to approach that. But the one big new requirement is that all training materials must be posted on the school's website if you have a website. So I think there's going to be some reassessment of the training that's been done, how much of it has been reduced to some kind of written or video materials that can be available online, and another review of how that will look as people take it offline and access it and likely critique it. And that, again, since the training you're going to do is going to happen at the beginning of the semester one way or the other, this is going to have to be dealt with sooner rather than later. I'll also note, given the requirements of the hearing, that both the advisors and the decision makers are going to have to be trained on the relevance in questioning and the rape shield protections, so that they know how to implement them, and it's clear that we have trained both the advisors and the decision makers on those. I think that's it. Done, and we have 3 minutes left.
Yeah, I think we do have time for a couple of questions here, Gail, just because I've been looking at them here. There's a question regarding the cross-examination and the preclusion of relying on somebody's statement if they don't submit to cross-examination. What does that mean? Does it mean refusing to answer questions that are asked? Or does it more generally mean not participating in a hearing process? The answer is the former. So what this means for practical purposes is that a party cannot show up at the hearing, decline to answer questions, but because they showed up, still ensure that their statements can be used. Really, they need to be willing to submit to those questions if they want their questions to their statements to be considered in determining responsibility. One other question here: what if a student wants another student who is clearly unqualified to be their cross-examining advisor? What if they choose a parent? What should we do about that? This really is not changed from before, other than the function that the advisor is playing in the hearing at most institutions. The advisor of choice rule still applies. So as bad a choice as that might be for a student, I think the institution needs to allow it at that point. And if it allows that other student or the parent to be the one doing the cross-examining, then I think it's fulfilled its obligation under the regulation. The more interesting question in my mind is, if somebody doesn't have an advisor, the other party has, counsel who is going to serve as the advisor, how are we feeling institutionally about appointing somebody who is not a lawyer to cross-examine for the party who doesn't have the advisor? Clearly, that would be permissible under the regulations. Whether it's a good idea optically is another question that I think institutions are going to need to wrestle with, but one that has clearly cost and logistical implications as well.
Okay, and looking through the questions, one overriding one was, will these slides in this presentation be available? And the answer, Kathy, correct me if I'm wrong, is yes, both the slides and the recording of this presentation will be available on Bond's website. Give us a little time to get it ready and cleaned up, but it will be available. There is also a bunch of questions that were a little confused about the issue of the real-time decision and the cross-examination. So just to go back and go through that again, advisors ask the questions. They have to be relevant to the matter being disputed in the hearing, and they have to honor rape shield protections. And if they are deemed by the decision maker to be not relevant or not following the rape shield protections, the decision maker has to, at that time, in the live hearing on their feet, rule on the question and stop it ideally before it's asked. So that's an important thing for people to understand and clarify, because it does require that there be some significant skill in the decision maker to be able to think on their feet always as questions are being asked about the relevance of the question, whether it's honoring the Rape Shield protections.
So with that, I think we are just about at the end of our allotted time. As I mentioned at the outset, we will be having a series of webinars May 18th, 20th, and 27th at noon on doing a deeper dive into particular areas of the regulations. Watch for those announcements to be coming forth shortly. We welcome your participation. More broadly, we are here to help you through all of this. The department seems to be unconcerned by the fact that none of us are on campus, or fewer of us are on campus right now, and that feel that they've been generous in giving us a whole 3 months to do this. Believe me, we know this is a heavy lift. We know that it is anxiety provoking. We will be here to help you through all of this, again, starting with these webinars, but then more directly as you go forward from here. So again, thank you everybody for your participation. I'm sure we'll talk to many, if not most of you soon, and enjoy the rest of your day.
Thank you.